Rule 73 Venue and Process. Section 1. Where estate of deceased persons settled. If the decedent is an inhabitant of the Philippines at the time of his death, whether a citizen or an alien, his will shall be proved, or letters of administration granted, and his estate settled, in the court of first instance in the province in which he resides at the time of his death, and if he is an inhabitant of a foreign country, the court of first instance of any province in which he had estate. The court first taking cognizance of the settlement of the estate of a decedent, shall exercise jurisdiction to the exclusion of all other courts. The jurisdiction assumed by a court, so far as it depends on the place of residence of the decedent, or of the location of his estate, shall not be contested in a suit or proceeding, except in an appeal from that court, in the original case, or when the want of jurisdiction appears on the record.
Where estate of deceased persons settled. Rule 73, Section 1. The estate of a deceased person shall be settled in the RTC, formerly CFI, of the province where the decedent resided at the time of death if he is a resident of the Philippines, or in any province where he had estate if he is a non-resident. The court first taking cognizance of the case shall exercise exclusive jurisdiction, and such jurisdiction cannot be collaterally attacked. Under Rule 73, Section 1 of the Rules of Court. 1. Resident decedent, Philippines or alien residing in PH. Estate is settled in the province of residence at time of death. Residence refers to actual habitation, physical presence, place of abode, not merely legal domicile. 2. Non-resident decedent, foreign inhabitant. Estate is settled in any province where he has estate. 3. First Court Rule. The court that first takes cognizance acquires exclusive jurisdiction. 4. Collateral Attack Rule. Jurisdiction cannot be questioned in a separate proceeding, except on appeal in the same case, or when lack of jurisdiction appears on the record. Improper venue must be raised through a motion to dismiss before submitting to the court's jurisdiction. Otherwise, it is waived. If a decedent was residing in Davao City at the time of death, the proper venue for probate is the RTC of Davao. If a petition is first filed in Manila and that court assumes jurisdiction, it excludes all other courts from later taking cognizance of the same estate. Even if another party believes the case should have been filed in another province, they cannot file a separate case to challenge venue. They must raise it on appeal or when lack of jurisdiction is evident on the record. Thus, estate settlement follows the rule of residence or location of estate, and the court first acquiring jurisdiction retains exclusive control over the proceeding, which cannot be collaterally attacked except in limited instances. Venue refers to the place where a case is filed, while jurisdiction refers to the authority of the court to hear and decide the case. In Rule 73 on settlement of estate, venue is determined by law, specifically, the residence of the decedent at the time of death if he is a resident of the Philippines, or the location of his estate if he is a non-resident. Jurisdiction, on the other hand, is the power of the RTC to take cognizance of probate cases as granted by law. Venue is procedural and may be waived if not seasonably objected to, while jurisdiction is substantive and cannot be conferred by agreement, waived, or cured by silence. Thus, improper venue may result in dismissal if timely raised, but lack of jurisdiction renders proceedings void. Garcia Fuel v. Court of Appeals. Gr. No. L. 40502 November 29, 1976. Facts. Teodora Fuel died intestate leaving several properties. A petition for the issuance of letters of administration over her estate was filed before the court of first instance. The opposing party questioned the proceedings, arguing that the petition had been filed in the wrong province because the decedent allegedly resided elsewhere at the time of her death. It was argued that because the petition was filed in the wrong court, the probate court did not acquire jurisdiction over the estate proceedings. The controversy reached the Supreme Court to determine whether the residence of the decedent affects the jurisdiction of the probate court or merely the venue of the action. Issue: whether the residence of the decedent determines the jurisdiction of the probate court over estate proceedings. Ruling: no. The Supreme Court ruled that Rule 73, Section 1 refers only to venue, not jurisdiction. Jurisdiction over probate and estate proceedings is conferred by law, while Rule 73 merely prescribes the proper place where the petition should be filed. Consequently, filing in the wrong venue does not divest the court of jurisdiction over the subject matter. Improper venue is merely procedural and may be waived if not seasonably objected to. Doctrine: Rule 73, Section 1 governs venue, not jurisdiction. Residence determines only the proper place for filing the petition. Pedro died while actually residing in Cebu City. His daughter filed a petition for letters of administration before the RTC of Davao City. His son moved to dismiss, arguing that because Pedro resided in Cebu, the RTC of Davao had no jurisdiction over the settlement proceedings. Is the motion correct? No. Rule 73, Section 1 provides that estate proceedings should be filed where the decedent resided at the time of death. However, in Garcia Fuel v. Court of Appeals, the Supreme Court held that this rule pertains only to venue, not jurisdiction. Although Pedro resided in Cebu, filing the petition in Davao merely affects the venue. Jurisdiction over the subject matter remains with the court as conferred by law. Improper venue is waivable if not timely objected to. The RTC of Davao is not deprived of jurisdiction. At most, the petition may be dismissed for improper venue if timely raised. Roberts v. Leonidas. Gr. No. L. 55509 April 27, 1984. Facts: Edward M. Grimm died leaving wills that had already been admitted to probate in Utah, USA. Despite the existence of these wills, his daughter from his first marriage filed an intestate proceeding in Manila, alleging that he died without a will. Subsequently, Grimm's second wife filed a petition for the reprobate of the foreign wills. The daughter argued that the intestate proceedings should continue because they had been instituted first. The issue before the Supreme Court was whether intestate proceedings should continue despite the existence of a will. Issue: whether intestate proceedings should continue despite the existence of a will. Ruling: no. The Supreme Court held that probate of a will is mandatory whenever a decedent dies testate. It would be anomalous for the estate of a person who left a valid will to be settled through intestate proceedings. Thus, the intestate proceeding should be consolidated with the probate proceeding. If the will is ultimately denied probate, the intestate proceeding may continue. Doctrine: testate proceedings take precedence over intestate proceedings. One died leaving a valid will. Before the will was discovered, one heir filed intestate proceedings. Later, another heir presented the will for probate. The first heir insists that the intestate proceedings should continue because they were filed first. Is he correct? No.
Under Roberts v.
Leonidas, probate is mandatory whenever a decedent leaves a will. Testate proceedings take precedence over intestate proceedings because the law seeks to carry out the wishes of the testator. Although the intestate proceedings were filed earlier, the existence of the will requires the court to first determine its validity through probate. Only if the will is disallowed may the intestate proceedings continue. The probate proceeding should take precedence, and the intestate case should yield to or be consolidated with the testate proceeding. Uriarte v. Court of First Instance. Gr. No. L. 21938 September 30, 1977. Facts: Vicente Uriarte, who claimed to be the natural son of the decedent, instituted intestate proceedings in Negros Occidental for the settlement of his father's estate. The decedent's other heirs opposed the petition, claiming that the decedent had actually executed a last will and testament. Instead of presenting the will in the pending intestate proceedings, they filed a separate petition for probate before another court in Manila. The issue arose as to the proper procedure when a will is discovered while intestate proceedings are already pending. Issue: whether a separate probate proceeding should be instituted when a will is discovered during pending intestate proceedings. Ruling: the Supreme Court ruled that the will should first be submitted for probate because probate is mandatory whenever a will exists. The probate proceeding should replace the intestate proceeding. However, if the will is eventually denied probate, the intestate proceeding should continue. The court also observed that the heirs should have presented the will before the court where the intestate proceeding was already pending instead of filing another case elsewhere. Doctrine:
whenever a will is discovered, probate proceedings take precedence over intestate proceedings.
During pending intestate proceedings, the decedent's children discovered a duly executed will. Instead of presenting the will in the existing intestate case, they filed another probate case before a different RTC. Was the proper procedure followed? No.
In Uriarte v.
Court of First Instance, the Supreme Court held that when a will is discovered during intestate proceedings, probate proceedings should first be undertaken, and the will should generally be presented in the pending estate proceedings. The heirs should have presented the will in the pending intestate proceedings so that the probate court could first determine its validity. Filing a separate probate case in another court was procedurally improper. No. The proper remedy was to submit the will in the pending estate proceedings for probate. Cuenco v. Court of Appeals. Gr. No. L. 24742 October 26, 1973. Facts: after the death of former Senator Mariano Cuenco, his children from his first marriage filed intestate proceedings before the RTC of Cebu, alleging that he died without a will and was a resident of Cebu. A week later, his surviving spouse filed a petition for the probate of his alleged will before the RTC of Quezon City. The heirs argued that because the intestate proceeding had been filed first, the Cebu court had already acquired exclusive jurisdiction over the settlement of the estate. The issue before the Supreme Court was whether the mere filing of the first petition automatically vested exclusive jurisdiction in the first court. Issue: whether the first court where an estate petition is filed automatically acquires exclusive jurisdiction. Ruling: no. The Supreme Court clarified that Rule 73 does not state that the court where the petition is first filed automatically acquires exclusive jurisdiction. Rather, it is the court that first takes cognizance of the settlement proceedings that acquires exclusive jurisdiction. Taking cognizance means the court has actually acted upon and assumed jurisdiction over the case. Doctrine: first filing is not equivalent to first taking cognizance. An intestate petition was filed first before the RTC of Cebu. Before the Cebu court acted on the petition, another heir filed a petition for probate of the decedent's will before the RTC of Quezon City, which immediately took cognizance of the case. Which court has exclusive jurisdiction? The RTC of Quezon City. Rule 73 provides that the court first taking cognizance of the settlement proceedings exercises jurisdiction to the exclusion of all others.
In Cuenco v.
Court of Appeals, the court held that mere filing of the petition is insufficient. Although the Cebu petition was filed earlier, the Quezon City Court was the first to actually take cognizance of the probate proceedings. The RTC of Quezon City acquired exclusive jurisdiction. Heirs of Ipon v. Ricaforte. GR number 198680 July 8, 2013. Facts: Magdalena Ipon died intestate without children, leaving several parcels of land. After her death, Godioso Ricaforte executed an affidavit of self-adjudication, claiming that he was the sole heir of Magdalena. Based on this affidavit, he caused the transfer of the titles to his name. Thereafter, the petitioners, who were Magdalena's alleged collateral relatives, filed an ordinary civil action for cancellation of title and reconveyance, alleging that they were the lawful heirs of Magdalena and that Gaudioso unlawfully adjudicated the estate to himself. Gaudioso argued that the petitioners had no cause of action because they had never been judicially declared as Magdalena's heirs. Despite this, the trial court ruled on the issue of heirship in the ordinary civil action. The case reached the Supreme Court to determine whether the RTC could determine heirship in an ordinary civil action. Issue: whether the RTC, in an ordinary civil action for cancellation of title and reconveyance, may determine who the lawful heirs of the decedent are. Ruling: no. The Supreme Court ruled that the determination of who the lawful heirs of a deceased person are is a matter that belongs exclusively to a special proceeding for the settlement of the estate. An ordinary civil action is intended to enforce or protect rights, while a special proceeding is intended to establish a status, right, or particular fact. Since declaring a person as an heir establishes a legal status, it must be done in the proper probate proceeding. Accordingly, the RTC erred when it declared who the lawful heirs were in an ordinary action for reconveyance. Doctrine: the declaration of heirship must be made in a special proceeding for the settlement of the estate, not in an ordinary civil action. Exception: the court recognized exceptions where a separate special proceeding may no longer be necessary, such as 1. The parties voluntarily submitted the issue of heirship to the trial court and fully presented their evidence, or 2. A special proceeding had already been completed and the issue of heirship had already been settled. Maria died intestate. Pedro immediately executed an affidavit of self-adjudication and transferred all the properties to his name, claiming to be the sole heir. One thereafter filed an ordinary action for cancellation of title and reconveyance, praying that the RTC declare him one of Maria's lawful heirs. May the RTC determine one's heirship in the ordinary civil action? No.
Under heirs of Ipon v.
Ricaforte, the determination of who the lawful heirs of a decedent are belongs exclusively to a special proceeding for settlement of estate because it involves the establishment of a legal status. One's complaint for cancellation of title and reconveyance is an ordinary civil action. Although ownership of the properties is in issue, his claim necessarily depends on first establishing that he is a lawful heir. Such determination cannot be made in an ordinary action. No. One must first establish his heirship in the proper special proceeding before pursuing his claim over the estate. Paciols, Jr. v. Chuatico Ching. GR number 127920 August 9, 2005. Facts: Miguelita Ching Paciols died intestate, leaving substantial real and personal properties. Her surviving husband, Emilio Paciols, filed a petition for the settlement of her estate and was appointed administrator. Miguelita's mother, Miguela Chuatico Ching, opposed the proceedings, claiming that a substantial portion of the properties listed in the inventory actually belonged to her and not to the estate. She insisted that the probate court first determine ownership before proceeding with the partition of the estate. The probate court scheduled hearings to determine whether Miguela was indeed the true owner of the disputed properties. Emilio questioned the probate court's authority, arguing that questions of ownership involving third persons could not be finally determined in probate proceedings. The issue reached the Supreme Court. Issue: whether the probate court may finally adjudicate ownership of properties claimed by a third person adverse to the estate. Ruling: no. The Supreme Court held that a probate court exercises only special and limited jurisdiction. Its principal function is to settle the estate, not to decide ownership disputes between the estate and third parties. The probate court may only make a provisional determination of ownership to decide whether a property should be included or excluded from the estate inventory. Such determination is merely incidental to estate administration and does not bind the parties on the issue of ownership. Where a third person claims ownership adverse to the estate, the controversy must be resolved in an ordinary civil action before a court exercising general jurisdiction. Doctrine. A probate court cannot finally determine ownership of properties claimed by third persons. Its determination regarding inclusion in the inventory is merely provisional and interlocutory. During the settlement of Rosa's estate, her sister claimed that several parcels of land listed in the estate inventory actually belonged to her by virtue of deeds executed during Rosa's lifetime. She asked the probate court to declare her the owner. May the probate court finally adjudicate ownership? No.
In Pacios, Jr. v.
Ching, the Supreme Court held that probate courts possess only limited jurisdiction and cannot finally resolve ownership disputes involving third persons. Since Rosa's sister claims ownership adverse to the estate and not merely as an heir, the dispute goes beyond estate administration. The probate court may only determine whether the properties should provisionally remain in the inventory. Final ownership must be resolved in an ordinary civil action. No. The probate court cannot finally adjudicate ownership of the disputed properties. Arenas vs. Mercado. GR number 156407, January 12, 2011. Facts. Emigdio Mercado died intestate. His surviving spouse, Teresita Mercado, was appointed administratrix of his estate and submitted an inventory stating that Emigdio left only personal properties. However, Thelma Arenas, one of Emigdio's children from his first marriage, objected to the inventory. She alleged that several real properties, including the Badian property, had been improperly excluded because they still formed part of Emigdio's estate despite having been transferred to a corporation shortly before his death. The parties agreed to submit the issue to the probate court for determination of whether the disputed properties should be included in the inventory. The RTC ordered the inclusion of the Badian property in the inventory. The ruling was challenged on the ground that probate courts have no jurisdiction over questions of ownership. Issue. Whether the probate court may determine whether disputed properties should be included in the estate inventory. Ruling. Yes. The Supreme Court ruled that although probate courts generally cannot adjudicate ownership, they may provisionally determine whether certain properties should be included in or excluded from the inventory of the estate. Moreover, the court emphasized that exceptions exist where the probate court may resolve ownership issues with finality, namely 1. When all the parties are heirs of the decedent. 2. When the parties voluntarily submit the ownership issue to the probate court. 3. When no rights of third persons are prejudiced, or 4. When the issue involves collation or advancement. Since the parties voluntarily submitted the issue and no third-party rights were impaired, the RTC properly exercised its authority. Doctrine. The probate court may determine ownership where all interested parties are heirs, they consent to the court's jurisdiction, and no third-party rights are prejudiced. During the settlement of Carlos' estate, all his children disagreed on whether a parcel of land transferred shortly before his death still formed part of the estate. They jointly asked the probate court to resolve the issue. No third persons claimed ownership. May the probate court determine ownership? Yes.
Under Arenas vs. Mercado, although probate courts generally have only limited jurisdiction, they may determine ownership where all the interested parties are heirs. They voluntarily submit the issue to the probate court, and no rights of third persons are prejudiced.
Here, the dispute is solely among Carlos' heirs. They expressly agreed to submit the ownership issue to the probate court, and no third party claims any adverse interest. Thus, the issue is merely incidental to the settlement of the estate and falls within one of the recognized exceptions. Yes. The probate court may validly determine the ownership of the disputed property under the recognized exceptions.
Section 2. Where estate settled upon dissolution of marriage. When the marriage is dissolved by the death of the husband or wife, the community property shall be inventoried, administered, and liquidated, and the debts thereof paid, in the testate or intestate proceedings of the deceased spouse. If both spouses have died, the conjugal partnership shall be liquidated in the testate or intestate proceedings of either.
Rule 73, Section 2, where estate settled upon dissolution of marriage. This provision explains what happens to conjugal or community property when marriage ends by death, and where it should be settled procedurally. If both husband and wife die, e.g., accident, there is no surviving spouse to start a single proceeding. Thus, the law allows liquidation in either spouse's estate case. This avoids procedural deadlock and ensures only one liquidation process is used. Legal effect. Makes liquidation of conjugal/community property mandatory in probate. Prevents filing of separate civil actions for partition after death. Ensures creditors are paid before heirs receive anything. Integrates family property regime settlement into estate proceedings. Core concept. When a spouse dies, you cannot immediately divide the property between the surviving spouse and heirs. The law first requires that the marital property regime be liquidated inside the estate, probate, case of the deceased spouse. This ensures debts are paid first. Net estate is correctly determined. Rightful shares are computed properly. What inventoried, administered, and liquidated means. Before any distribution happens, the following steps must occur. Inventory, listing all properties belonging to the marriage, real and personal. Administration, management of the assets, including preservation and collection of assets or receivables. Liquidation, determining which properties are conjugal/community, which belong to the exclusive property of each spouse. Total debts and obligations. Net remaining estate. Only after this can partition and distribution be made. Why it must be in probate estate proceedings. The law requires it to be done in the testate or intestate proceedings of the deceased spouse because the estate court already has jurisdiction over the deceased person's property. It avoids multiple lawsuits, no separate partition case needed. Creditors must be protected before heirs divide anything. The surviving spouse's share must be legally determined, not assumed. So even if the surviving spouse is still alive, the property is not immediately divided, it is funneled through probate first. Alapio vs. Court of Appeals. GR number 134100 September 29, 2000. Facts. A creditor sought to collect a debt chargeable against the conjugal partnership by filing an ordinary civil action directly against the surviving spouse after the death of the other spouse. The issue was whether the creditor could bypass the estate proceedings and directly sue the surviving spouse. Issue. Whether a creditor may file an ordinary collection case against the surviving spouse after the death of one spouse. Ruling. No. The Supreme Court held that upon the death of one spouse, administration of the conjugal partnership ceases to belong to the surviving spouse and passes to the administrator or executor appointed by the probate court. Accordingly, claims against the conjugal partnership must be filed in the estate proceedings, not in an ordinary civil action. Doctrine.
Upon the death of one spouse, claims against the conjugal partnership must be filed in the settlement proceedings of the deceased spouse.
Husband H died leaving unpaid obligations chargeable against the conjugal partnership. Instead of filing a claim in the settlement proceedings, creditor C filed an ordinary collection case directly against wife W. Is the action proper? No. Rule 73, Section 2 requires that upon the death of one spouse, the community or conjugal property shall be inventoried, administered, and liquidated in the settlement proceedings.
In Allapio v.
Court of Appeals, the Supreme Court held that claims against the conjugal partnership must be presented in the estate proceedings. Since H has already died, administration of the conjugal partnership has passed to the administrator appointed by the probate court. Creditor C cannot bypass the probate proceedings by directly suing wife W. No. The proper remedy is to file a money claim in the settlement proceedings of H's estate.
Section 3. Process. In the exercise of probate jurisdiction, courts of first instance may issue warrants and process necessary to compel the attendance of witnesses or to carry into effect their orders and judgments, and all other powers granted them by law. If a person does not perform an order or judgment rendered by a court in the exercise of its probate jurisdiction, it may issue a warrant for the apprehension and imprisonment of such person until he performs such order or judgment, or is released.
Rule 73, Section 3, Process. This provision defines the powers of the probate court, RTC acting as probate court, in enforcing its authority during estate settlement proceedings. It clarifies that probate courts are not limited to passive fact-finding. They have full coercive and enforcement powers to ensure compliance with their orders. In essence, once a court is exercising probate jurisdiction, it can compel witnesses to attend hearings, enforce its orders and judgments, punish non-compliance through coercive measures such as imprisonment until compliance. This ensures that estate settlement proceedings are not frustrated by disobedience or delay. Legal effect. Probate courts have inherent coercive power within probate jurisdiction. They may issue warrants of arrest to compel compliance, not criminal prosecution. Orders of imprisonment, civil contempt type detention until compliance. Ensures effective enforcement of probate orders. Makes probate proceedings fully functional, not merely declaratory. Important distinction. This is not criminal punishment, but coercive imprisonment to compel compliance.
Section 4. Presumption of death. For purposes of settlement of his estate, a person shall be presumed dead if absent and unheard from for the periods fixed in the Civil Code. But if such person proves to be alive, he shall be entitled to the balance of his estate after payment of all his debts. The balance may be recovered by motion in the same proceeding.
Rule 73, Section 4, Presumption of Death. This provision deals with the procedural presumption of death used specifically for estate settlement when a person has been absent and unheard from for the periods provided in the Civil Code. The law allows the court to proceed with probate or intestate settlement even without actual proof of death, as long as the legal requirements for presumption are met. This is meant to avoid delay in the settlement of estates. However, the presumption is not final or conclusive. If the person later appears alive, the law protects his rights by allowing him to recover what remains of his estate after debts have been settled. The periods provided in the Civil Code refer to the rules on presumption of death under the Civil Code of the Philippines. Article 390, Civil Code, Ordinary Presumption of Death, after 7 years of absence, or 10 years if necessary for succession purposes under certain contexts in practice. Article 391, Civil Code, Presumptive Death in special circumstances, e.g., danger of death situations like shipwreck, war, airplane crash, etc., where shorter periods apply, generally 4 years under extraordinary absence rules.
Summary of cases. In Garcia Fuel v. CA, Rule 73 concerns venue, not jurisdiction. In Roberts v. Leonidas and Uriarte v.
CFI, a testate proceeding takes precedence over intestate proceedings, and a discovered will must first be submitted to probate.
Cuenco v.
CA further provides that exclusive authority belongs to the court that first takes cognizance of the estate, not merely the court where the petition was first filed.
In Heirs of Ipon v.
Ricaforte, the court held that heirship must be determined in a special proceeding, not in an ordinary civil action.
However, under Pacios, Jr. v.
Ching, probate courts generally cannot finally determine ownership disputes involving third parties, and any determination is merely provisional for purposes of inventory.
Arenas v. Mercado recognizes an exception. The probate court may determine ownership when all parties are heirs, they consent to the court's determination, and no rights of third parties are affected.